Life Unrehearsed, brought to you by Lianas Senior Transition Support, helping you navigate elder care planning and life transitions.
And welcome back to Life Unrehearsed. My name is Matt Del Vecchio, specializing in life transitions, elder care planning, and the senior living industry. Corey is off today. In fact, she's in Toronto. She's the keynote speaker for the 2022 Mothers Against Drunk Driving Canada National Conference for Victims of Impaired Driving. Very proud of you, Corey. And she's speaking in Toronto today. I wanted to wish a Happy New Year to those celebrating Rosh Hashanah, Shana Tova, and thank you for listening here to Life Unrehearsed. And we want to welcome you to our segment called Helping Mums and Dad, which we do in the second half of every show here on Life Unrehearsed. And it's done to support the sandwich generation with unique topics and dynamic guests. Sandwich generation, of course, being the parents who may have their own children and also concerned about their parents as well. I wanted to bring up a discussion, the topic of getting our legal documents in order. I see this as a major issue in my day-to-day world of helping seniors in transition. And so, for example, you may think, oh, will is done, check. The power of attorney is done, check. We're good. Well, in fact, the stats don't really support that. Almost, it's now over 50% of people do not have a will or have updated their will in the last 5 years. Absolutely has to get done. And you think you might be covered if you have a power of attorney for mom, dad, grandparent, brother, sister, or a spouse. In fact, that's not true at all, especially if your loved one is considered inapt due to such things as dementia or a stroke that has permanently affected the individual. And this is where something called a protection mandate comes into play. And it can really be confusing for people. And usually it's done in a context when it's crisis mode. And it's always best to be proactive and get things in order. And that's why we want to bring in clinical social worker Megan Rainish to get a better understanding of protection mandates and the homologation process. Megan, welcome back to Life Unrehearsed.
Hi, Matt. It's great to be back. Thanks for having me.
Well, thank you for joining us on the show. I know personally you are one very busy person, and thank you for taking a little time to share with our listeners on such an important topic about the confusing legal documents that are out there. So let's start it off, Megan, with, can you define for us what is a protection mandate?
For sure. So you're right. It is a complicated process. So I hope to clarify for your listeners. So a protection mandate is essentially a document that allows a person of full age to determine who will make decisions for them and the type of decisions. So in the event that they are no longer able to do so themselves. And it comes into effect once it is what's called homologated. So the person or persons that you choose to represent you are called mandataries. And your mandatary's role will be to make decisions regarding your well-being or your property and finances should you become incapacitated and are no longer able to make decisions for yourself.
Okay.
So you can decide. Yeah, sorry, go ahead.
And you were just going to say you can decide on the mandatory, I guess, or
exactly. You can assign multiple people as well.
All right. And so important, because what needs to be emphasized here is a protection mandate is you are creating this protection mandate while you are apt, and you are assigning mandatories in case you become incapacitated. And that's what a lot of people don't really seem to understand. And I want to bring in and tie in power of attorney, because so often we both hear, oh, well, I've got a power of attorney, I'm good. So how does a protection mandate differ from a power of attorney?
So, yeah, a power of attorney is a legal document that you sign to give a person or multiple people the authority to manage your money and property on your behalf. But you must be mentally capable or apt at the time you sign the power of attorney for it to be valid. And what this does is it provides your attorney the ability to manage your finances and property while you are still mentally capable of managing your own affairs. But this document no longer is valid if you do become mentally incapable of managing your affairs. And that's when other measures would need to be implemented, such as having the protection mandate or, getting a tutorship, for example.
You're listening to Life Unrehearsed. Matt Delvecchio here, and we're talking to clinical social worker Megan Rainish about legal documents such as power of attorney and protection mandates and the homologation process. So glad you brought that up about power of attorney, because it really is a temporary document. While you are apt, you are assigning someone. A lot of the times it's due to for financial reasons, being able to pay bills and so on. And I just want to get into one more clarity, a thing to clarify here for you, Megan. The difference between a protection mandate and a curatorship.
Yes, that's a good question. So they're both forms of protective supervision, and there's actually a new law coming into effect November 1st. So curatorship will actually be known now as tutorship, and I can touch on that later, the new law. But what I would say is that while a mandate has been written up at a time where the individual concerned makes the decision for themselves as to who they wish to represent them and decisions for their care and so on, seeking a tutorship would mean that the person does not have a mandate, and therefore typically a family member or close friend would have to elect themselves, and they must ask the court to implement the protective supervision for their loved one. So basically, to simplify, if a person is incapacitated and did not prepare a mandate, they would need to obtain a tutorship.
Got it. And of course, we're civil code and here in Quebec, and it is designed to protect the individual. So often we've heard, oh, don't worry, I've got a power of attorney. So the reality is, if you've got a protection mandate written up while you are apt, great. However, in real life, these sometimes don't get written up, and what you're saying now, it will be called tutorship, and there's a whole process in place for tutorship. Okay. Let's do the scenario. You have the protection mandate done up, and now the individual, your loved one, may, let's say, has Alzheimer's or dementia and is considered incapacitated. We have to go through a process called homologation. So can you explain what that means?
Sure. So having your protection mandate homologated encompasses many steps that would need to be taken through a proceeding with a notary or a lawyer. This procedure is known as homologation of the protection mandate. And what this involves is drawing up a request for homologation, sending the request to the incapacitated person and to other interested parties, and obtaining all necessary documents. So this would include a medical evaluation from a doctor and a psychosocial evaluation from a social worker, the actual mandate, let's say their birth certificate, just to name a few. And then you'd actually have to file these documents in court, and it would be up to the judge who then makes the final decision as to whether this homologation will go through.
Right. So in other words, just because you have a protection mandate, great, that's a piece of paper, a legal document saying I will assign so on as my mandatory. Now when you actually have to execute that mandate, you just can't show that document. You actually have to go through the courts, and the courts are designed to protect the individual, and this is why you need to go through this homologation process. So very well explained, Megan. Thank you very much. We actually have to head out to traffic here, Megan, but when we come back, we're going to be, you mentioned some of the changes to the law in the public curator, and I want to address that because it's quite important. And welcome back to Life Unrehearsed. Matt Delvecchio here, and we're continuing our segment called Helping Moms and Dads. And this afternoon, we're talking to clinical social worker Megan Rainish about protection mandates and the homologation process. And just a quick little recap, we had discussed on the first half of this interview that power of attorney may not be enough. In other words, if all of a sudden your loved one becomes incapacitated due to things like dementia or Alzheimer's, always best to have a protection mandate and assigning someone as your mandatory. And in order for this to be executed, or homologated is the fancy technical term, there are a couple of assessments that need to be done. One is a medical assessment, of course, from a doctor to provide information and declare if the individual is incapacitated or not. And one of them, a very important document, actually much more thorough than the medical assessment, is called a Psychosocial Assessment done by a social worker. And we have Megan Rainish, a clinical social worker, on the line to help clear up some of these things. So Megan, what is involved in a psychosocial assessment?
So a psychosocial assessment is first of all, as you mentioned, must absolutely be completed by a social worker. This is a reserved right of practice, so no other professionals can perform this assessment. And basically what's involved is a proceeding between the social worker and the client, so meaning the incapacitated person, and the family or close friends. So the social worker would assess the incapacitated person's psychosocial situation by analyzing their daily routine, their family situation, their overall history, and the progression of their cognitive impairment. And they would also evaluate the person's level of autonomy when carrying out everyday tasks such as banking, domestic tasks, hygiene care, and so on. And as I mentioned, in order to have the mandate homologated, the assessment must conclude that the person is indeed incapacitated. The social worker would make that recommendation in addition to the doctor. Something, I want to mention that the social worker must always take into account is the incapacitated person's opinion as well, whenever possible, as regardless of incapacitation, their rights must still be maintained.
Yeah, so important. And again, we mentioned Civil Code in Quebec. This is ultimately what it's about. The rights of the individual are maintained at all times. Megan, this is obviously resonating with a lot of our listeners. We're getting texts in and asking how they can get the broadcast and can we listen to it. So yes, this interview and all of Life Unrehearsed interviews are available on the CJD website. Usually it's posted about an hour after the show, and just look up CJD Life Unrehearsed. Now, continuing along, Megan, about psychosocial assessments and why we wanted to have you on specifically this time of year, because November 1st, there are some changes to the laws of the public curator. Can you review some of them specifically for the psychosocial assessments?
For sure. So there's a bunch of changes that are coming into effect. And I'd say some of the main objectives of the new law were to better highlight the remaining faculties of a vulnerable client who is, at this stage requiring legal representation. I find this very dignified in trying to conserve any remaining autonomy. So there now exists new types of measures which can further protect the individual experiencing challenges with memory. For example, there is now what's called the assistance measure, which would be for anyone who is living with a difficulty, such as a diagnosis of dementia, for example, who would like help from someone close to them in order to make decisions or exercise their rights. So as an example, let's say someone in theory is still able to make decisions for themselves, but is starting to have trouble understanding information or dealing with service providers. They might need someone to represent them for a certain task, but the vulnerable person would have to understand the scope of this measure and be able to express their wishes or preferences. And then the assistant would have to be basically act as the intermediary with various organizations or companies or professionals. Another thing I can mention is a new measure called temporary representation. So let's say a person is declared incapable but only needs to be represented for a specific act. A temporary representative would be appointed to perform this act on their behalf, and the protection measure would be terminated once this act has been completed. And the final, kind of change, I'll say, to the law, so what we previously know as a curatorship is now known as a tutorship. So, for example, obtaining a private or public curatorship in the past would now mean the concerned person has been declared incapable or inapt and now requires complete representation to exercise many of their rights, by a tutor, as I mentioned. And this measure can be modulated based on the person's faculties in order to preserve their autonomy, as I said. This also, I should note, is in the event that a protection mandate wasn't prepared, as we discussed earlier.
Right, exactly. You're listening to Life Unrehearsed. Matt Delvecchio here, and we're talking to clinical social worker Megan Rainish about protection mandates and the homologation process. As we discussed before, a will and a power of attorney is usually not even close to enough. And if ever it gets to a stage where someone is incapacitated or inapt, then a lot of these things come into effect. Many of the changes by the public curator are actually good changes. They come into effect November 1st, and Megan, your team has already had to start implementing some of these changes on the assessments that they're filling out. And just for, in terms of timing, if you were to say, Megan, but how long does the process take to receive a final decision from the courts? And I'll just preface that by saying, let's assume the notary or the lawyer that you've brought on board, you've got all the documents, everything's filled out properly. Now you're sending it to the courts for judgment. How long does that process normally take?
So it's a great question. I don't know that I have a definite response, unfortunately. But I've heard it can be as fast as a 6-week delay. Other times it can take up to 6 months. And I would say this varies and really depends on the circumstances or maybe how backed up the courts are. I feel that maybe the lawyer or notary involved in the case would maybe be in a better position to give a more clear timeline in regards to receiving the final decision from the courts. Like I said, depending on what time you're filing all the documents.
Right, understood. And also when we hear this figure, let's say of 3-4 months, understand that sometimes getting these assessments, particularly the medical assessments and psychosocial assessments, is going to take some time prior for the documents to be submitted to the courts. So, it's not something that's going to happen in a couple of weeks. So best to be proactive. Megan, one real quick question. Any suggestions to families about the importance of having their legal documents in order?
Oh, yes, for sure. So I would say it's extremely important to have certain legal documents in place so that in the event that you do become incapacitated, you have set out all of your decisions in writing. And this is a very dignified process and allows the individual the ability to have ownership over their rights and wishes. I feel that it is so much better to be prepared versus something happening unexpectedly and having nothing in place.
Right.
It's suggested to create these types of documents such as a will or power of attorney or a mandate when you're let's say younger and hopefully healthier. And, I would say, that having these documents, you should also reread them or review them every few years to ensure that your wishes haven't changed over time.
Absolutely. Megan, we're already at a time. We want to thank you very much. And how can people reach you?
Thank you so much. Thanks for having me. So I would say the best way to reach me is to go on the Lianas Services website. As a member of the team there and the team lead for psychosocial assessments, I believe, I hope I'm not wrong in saying this, but my email should be listed. Mm-hmm, yes. If not, you can reach out to Lianas directly and you can be connected to me.
All right. Megan, thank you so much. It's Megan Rainish helping us navigate the homologation process. She's a clinical social worker. Thank you for tuning in to Life Unrehearsed. Many thanks to our technical producers, Dean and Max, both of you today. You could listen to Life Unrehearsed here on CJD 800 every Saturday.